Hi, I am Joe Tierney, a shareholder with Meissner, Tierney, Fisher, and Nichols in Milwaukee. For the next few minutes, I will describe to you the current estate planning environment in Wisconsin and the changes that have made it better. By better, I mean that people who are engaged in estate planning now have far more freedom in design than they had in the past. For the most part, this improved environment is attributable to recent changes in the federal estate and gift tax, a 40% tax on property gifted during life and owned at death. But that's not exclusively true. Some important and helpful changes have been made in Wisconsin. The principal changes include, first, the great increase in 2010 in the unified credit, which now exempts $5,450,000 from the federal gift and estate tax. Second, the unlimited marital deduction in the computation of that tax. Third, portability, a new rule that permits the amount of the unified credit that the spouse who dies first didn't use to be used by the surviving spouse. Fourth, the adoption in Wisconsin of the marital property, essentially community property rules. And fifth, the stepped-up basis for both the deceased spouses and the surviving spouses' halves of community property to fair market value at the death of the first to die. Over the course of my career, I've been blessed to do estate planning for couples with long-term and stable marriages. The coming together of these changes has meant that couples in these marriages have many more alternatives and can more easily shape their estate plans to meet their objectives in disposing of property by gift or on death. The tax cost of doing this is greatly reduced and much more under their control. Consider, for example, a married couple with $10,900,000 of property who haven't used their unified credit on gifts. Under the Wisconsin marital property law, they can opt in and treat all of their property as marital property. That can be very good. At the death of the first to die, all of the couple's property would take a fully stepped-up basis for income tax purposes. But without portability, if the first to die, for our purposes, let's say it's the husband, would leave all of his property to a surviving spouse, at her death, $5,450,000 would be subject to the death tax because she would have only her own unified credit to reduce the tax attributable to the full $10,900,000 of property. So before portability, his assets would be put into a bypass trust that would not be subject to tax at his wife's death, with all of the associated costs and limitations, including, by the way, the absence of stepped-up basis on the assets in the trust at his wife's death. Portability became the law in 2010, though only became permanent in 2012. With portability, he can leave all of his property to her outright, and at her death, she'll have a unified credit of $10,900,000 to apply to the computation of the estate tax and get a full stepped-up basis for income tax purposes on all of this property. But again, this wouldn't be possible without the unlimited marital deduction. Until 1981, the marital deduction was limited to 1/2 of a decedent's adjusted gross estate, essentially assets minus liabilities. It was only then that the tax policymakers appreciated that there was no sense taxing an estate at the death of the first of the spouses to die, that the estate and gift taxes should be essentially intergenerational. In 2000, only $675,000 was excludable. By 2002, this amount was $1 million. By 2009, it was $3,500,000. In 2010, the unified credit was increased to $5 million and indexed, though this change really didn't become permanent until late 2012. But that's why the unified credit is now $5,450,000 in this year, 2016. This has had the effect of eliminating both the death tax for thousands of people and the social costs associated with efforts to avoid the tax and arrangements put in place to do so. For many, these changes in the unified credit have created the freedom I've mentioned. At the same time, the $1 million limit on using the unified credit on gifts was eliminated, so people can gift property without federal gift tax up to the overall unified credit amount, the $5,450,000, without the separate arbitrary limit of $1 million restraining them. Again, this has created degrees of freedom for taxpayers to make gifts of property without attracting the tax. Wisconsin has done its part. It has long since eliminated its gift and inheritance taxes, phasing them out in the early 1990s and eliminating the so-called decoupled pickup estate tax in 2012. There are many states that haven't done these things, including, for example, Illinois and New York. To ease the process of passing property on death, in 1985, in the legislation adopting marital property, Wisconsin adopted the so-called Washington Will, which enables a married couple to pass property without probate by simply providing so in their marital property agreement, thus reducing the scope of probate. Wisconsin has since created a similar device for singles. And as I mentioned earlier, it has permitted couples to opt in to marital property, thereby creating opportunities for significant basis step-up at the death of the first to die. What I have described is greatly simplified. For example, there are certain assets for which opting into marital property is unwise, and there are other implications in taking any of these steps. For those whose assets significantly exceed the $10,900,000, exposing them to estate and gift tax, there are plenty of other problems and opportunities, including a generation-skipping transfer tax that requires attention. But this estate planning environment is far better than it has been in the past. If you should need assistance in estate planning, we'll be happy to help you. Thanks for your attention. I hope the information I have shared with you proves useful.